A very warm greetings and welcome to Law and Life. I'm Shashank Mishra with renowned senior advocate of Supreme Court of India, Subodh Markandeji. So, who
Oh,
is Tarun Tej-Pal? Why is the media giving so much prominence to the interlocutory order denying him in-camera proceeding in an appeal pending before the High Court?
accused Tarun Tej-Pal is the co-founder and former editor-in-chief of Tehelka, a prominent print news magazine. So he was accused by one of his young lady colleagues of committing several criminal acts punishable under sections 354, 354A, 354B, 376, 2F and K, 341 and 342. These offences were allegedly committed by Tej-Pal on 21st November 2013 in an elevator in Hotel Grand Hyatt, Bombolin, Goa during Tehelka's own event called Think 13. After a protracted proceedings in which the accused challenged several interlocutory orders right up to the apex court, investigation followed by trial, Tej-Pal was acquitted on 31st May 2022 by the special judge, giving him the benefit of doubt. Against Tej-Pal's acquittal, the prosecution filed an appeal by special leave in Goa bench of the Bombay High Court. Tej-Pal then filed criminal miscellaneous application number 584 of 2021 in the High Court, praying that the hearing of the appeal may take place in camera under section 327 of the Code of Criminal Procedure 1973. So that application was rejected by the Goa bench of the Bombay High Court by its judgment and order dated 24th November 2021. Then Tej-Pal carried specially petition before the Supreme Court, and that's how the matter arose in the Supreme Court.
Sir, can you further explain more on that? How how he was put in and put into jail, and
Oh,
authorities have pronounced the constitution mentioned against them same point again.
In the Supreme Court, it was contended on behalf of accused Tej-Pal that High Court has fixed the hearing of the appeal in virtual mode, thereby exposing the privacy of the accused. In such an event, it was contended that Article 21 should be read as part of Section 327 so that the privacy of the accused is uh, protected. It was further argued that Section 327 of the Code of Criminal Procedure is designed to protect proceedings. That's what was emphasized, proceedings in a criminal case, and not just the prosecutrix. It was further contended that so many false cases are being filed against innocent people, and therefore Article 21 will have to be read into Section 327, as the accused is entitled to his right to privacy and reputation. Then the last contention was that Section 327 protects all proceedings under sections 376, 376A, 376B, 376C, and 376D of the Indian Penal Code. The Supreme Court, however, dismissed the special petition, holding that accused Tej-Pal is not entitled to the in-camera hearing of the appeal filed by the state of Goa against his acquittal by the trial court. Therefore, the Supreme Court declined to interfere with the impugned judgment of the Goa bench of the Bombay High Court. The Supreme Court, however, left it open to the High Court to hear the appeal either in virtual mode or uh, in the personal mode, that is, regular hearing in person.
So have you any comment on this outcome?
I must observe that Section 327 ensures what is called open court hearing, which is part of our public policy. Subsection 1 of Section 327 guarantees as a rule the hearing in the open court, that is, court in which public generally may have access to the extent the capacity of a court may allow. The proviso to subsection 1 gives a discretion to the court to bar the public generally or any particular person from having access to or be or remain in the courtroom or building used by the court. Subsection 2 of section 327 mandates that the inquiry into and trial of rape or any offense under sections 370, 376, 376A, 376B, 376C, 376D shall be conducted in camera. Its proviso confers upon the court power suo motu, that is of its own accord, or on application made by either party to allow any particular person to have the access to or be or remain in the courtroom or building used by the court. Where the proceedings are being held under subsection 2, it will be unlawful for under subsection 3 for any person to print or publish any matter in relation to any such proceeding except with the previous permission of the court. I think probably that's what Tej-Pal wanted to avail. During the hearing of the specially petition, the bench pointed out that the stage of availing section 327 is at the time of enquiry or trial and not at the stage of appeal. Lastly, what I would like to observe is
Yes,
that
sir.
judgment of is a very erudite judgment of 7 judges bench in Naresh Sridhar Mirajkar versus State of Bombay, State of Maharashtra, AIR 1967 SC, page 1, is an encyclopedic exploration of law bearing on almost all the aspects of in-camera proceedings. So if the viewers are so inclined, they
Yes,
may
sir.
read the judgment. It's a long judgment and several judgments, but that's the authentic and has been followed ever since 1967.
Yes, sir. So that's all for the day, sir. Thank you, sir, for elaborating on topic. And we will see you on the next video.
Thank you, Shashan.